Even if the Supreme Court decides that President Trump doesn't have the power to impose these tariffs under what's called the International Economic Emergency Powers Act, there are other ways they can impose tariffs. There are other statutes. The reason it would be incredibly disruptive is because it would mean everyone gets a refund. And by the end of the year, we're talking about maybe $130 billion worth of refunds. Big politics meets the law argument in front of the Supreme Court today. The president saying it's the most important case in, 100 years or something. I don't see how that's the case, only because this is the thing that a lot of people aren't talking about this case. Even if the Supreme Court decides that President Trump doesn't have the power to impose these tariffs under what's called the International Economic Emergency Powers Act, there are other ways they can impose tariffs. There are other statutes. There are other laws that they could try to use. But the reason it would be incredibly disruptive is because it would mean everyone gets a refund. And by the end of the year, we're talking about maybe $130 billion worth of refunds. So if the court determines that the president does not have the power, and this is not with regard to all the tariffs that he's imposed, just some of them, but if he doesn't have the power to do it under the International Economic Emergency Powers Act, IEEPA, then all these refunds are going to go into place. Now, lower courts have determined using different kinds of reasoning that he didn't have the power to do it. We're talking about analyzing this statute, and it's important to know that this statute is basically something that was a revision that was created in 1976, 77, and it was based on a previously existing law. My understanding is that the reason that they made some of the revisions was to prevent the president from overstepping his bounds, meaning to contain the power. So right there, you got to ask yourself, so wait a second. This statute doesn't mention the word tariffs in it. And it was revised in the late 70s to try to contain the president's power. So what is the argument that could even be made as to how he could have the power to do it? Well, the answer is that when a president declares an emergency, generally a lot of deference is given to the president in making that decision. Now, it's interesting because one of the lower courts, the Court of International Trade, found that some of Trump's orders lacked an adequate basis in the emergency conditions, basically saying, what's the emergency? Oh, you're saying it's fentanyl? Oh, you're saying it's unfair tariffs coming from other countries? That's not an emergency. But that's not considered the strongest argument. The strongest argument, we heard this a lot today in the arguments, is where is actually the power granted for the president to deal with tariffs in IEEPA? Because it refers to, there's one reference, the power to regulate. Does that mean power to tariffs, which is typically a congressional power? So it was, look, a lot of people thought this was going to be a very close case. You listen to the arguments today, and it seems that a lot of the justices are very suspicious or dubious or concerned about the administration's arguments. Here is Justice Amy Coney Barrett with John Sauer, the Solicitor General, questioning him on the power. This is number one.
Has there ever been another instance in which a statute has used that language to confer the power? Well, putting aside Yoshida.
I mean, obviously, the other statutory example is just imports. The cases we rely on are cases where, for example, in Gibbons, it's Ogden and Justice Story's
But that just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
I think our argument goes a bit further than that as an interpretive matter, because if you look at that history, the history of delegations.
Could you just answer the justice's question?
Can you identify any statute that used that phrase to confer tariffs?
Yeah, the only two statutes I can identify now are TWIA, as interpreted in Yoshida, and then closely related, not regulate importation, but adjust imports in section 232.
Well, I think adjust imports is differently. So the answer is the contested application in TWIA, and then now in IEEPA.
And then, of course, I mean, there's a sort of direct line there.
Yeah, I understand that.
All right, that's not good. Right? I mean, you never know, right? You never know what the questions actually mean. You know, justices sometimes play little games with words, et cetera. But it doesn't seem good if he could potentially lose Amy Coney Barrett. And here is Justice Roberts. This is number 3, basically challenging the Solicitor General, been citing a case that he was saying really helped his argument. And Chief Justice Roberts challenges him on it. Let's listen.
This, an issue in Dames and Moore was a different provision of IEEPA, not at issue here, and certainly did not concern tariffs. So I don't quite understand how you can get as much out of Dames and Moore as you're trying to get.
Maybe I could put it this way. You don't dispute that Dames and Moore is, as you stated, narrow opinion. However, it address certain principles that we think are equally applicable here. For example, the interpretive principle. Dames and Moore held, and again, it was the power to nullify and void, not the power to regulate, but it's in the very same sentence, in the very same statute, and the court quoted the First Circuit opinion and said, look, this is sweeping and unqualified language, which it didn't disagree with. And then it said, this particular provision where Congress has given these broad verbs, I mean, regulate is a capacious verb, admittedly, so are nullify, so are void, so are frankly all the other verbs there in the language in IEEPA. The way the court thought about it is we are looking at this through the lens of Justice Jackson's opinion in Youngstown, and the court held specifically that these verbs place the president in Youngstown Zone 1.
Timothy Meyer is a professor of international business law at Duke University School of Law. He is an expert in international law, specialties in international trade, and U.S. foreign relations law. So he's kind of the perfect guy to talk about this. He's co-director of Duke Law's Center for International and Comparative Law, and he joins us now. Professor, thanks very much for coming on. Appreciate it.
Yeah, thanks. Happy to be here.
All right, so give us, first of all, your overview thoughts. I mean, people came into this thinking tough to call, right? No way to know exactly how the justices are going to come out. Everything you see about the analysis up to this point is, wow, these justices were pretty tough on the administration. You agree with that?
I think that's right. I think that, the 3 justices that I'm really watching in this case are Justice Barrett, the Chief Justice, and Justice Gorsuch. And I think that, you just played two clips by Justices Barrett and the Chief Justice that, were, I think, very tough on the government. I think Justice Gorsuch was tough on both sides. But I think the government came in with a sort of a very maximalist argument, and the court really wasn't hearing it.
What do you mean by that?
So the government's argument is basically you have this statute here that doesn't say anything about tariffs. It doesn't say anything about tariffs are just taxes, right? It doesn't say anything about that. You have a sort of a structure of the law here where there are, dozens of laws that delegate to the government the power to impose tariffs, but they all do so explicitly. And then you have a history here in which no president has ever used IEEPA, this law, to impose tariffs. So, those 3 things make this just right off the bat a tough argument for the government. And so what the government has really kind of leaned into is this idea that because tariffs are a tax on imports which originate overseas, that the president, his power over foreign affairs under the Constitution is sort of implicated here, and means that essentially, the government doesn't quite put it this way, but essentially you just need to defer to the government's interpretation of this term regulate to include the power to tax. And that's really where I think you saw the Chief Justice and Justice Barrett, particularly in those 2 clips you just played, really push back pretty strongly on that. And Justice Gorsuch actually pushed back on it as well. He sort of said, look, General Sauer, you're not really saying that these doctrines, things we call the non-delegation doctrine, the major questions doctrine, you're not really saying that those never apply to tariffs or foreign commerce. And the Solicitor General was forced to concede that they do apply in at least some form.
Well, and it does seem, and this gets a little technical, but we got a very smart audience here. So when it comes to what's called the major questions doctrine, right? It seems to me like if this doctrine exists at all, then it's got to apply in this case. And let's talk about what the major questions doctrine is. It basically says that if the president here, in this case, has claimed to use some sort of statutory authority in what's called an unheralded or transformative way, meaning you make a big deal, right? A big deal decision here to support something of, quote, vast economic and political significance. Basically, the government has to point to clear congressional authorization, meaning on major questions, the Congress has to have been clear in giving the president that power. How does that, what's even the argument that that wouldn't apply here?
So the argument that it wouldn't apply here is twofold. One argument is that it doesn't apply in foreign affairs. And so we sort of don't know yet whether it does apply in foreign affairs. The major questions doctrine, the version of it you just described, has really only been with us for about 6 or 7 years. And so the Supreme Court has not squarely addressed whether it applies in the foreign affairs context. But similar doctrines, something like the non-delegation doctrine, there's a long history of saying, they don't apply, or they don't apply in the same way in foreign affairs. And so the government is really saying, A, tariffs are a foreign affairs issue, and B, you should treat the major questions doctrine like you treat these other doctrines in the foreign affairs space and apply them deferentially. There's a secondary argument there as well, which is that certain types of administrative rules that apply to agencies, the head of the EPA or the Secretary of the Treasury, don't apply to the president. The Administrative Procedure Act doesn't apply to the president. And so there's a sort of a secondary argument that most of the lower courts have rejected, but that says, well, the major questions doctrine doesn't apply to the president. You didn't hear much about that one today, but you did hear this sort of foreign affairs argument come up. And Justice Kavanaugh has written, he wrote in it separately in a case earlier this year that involved a different tax issue to say, look, I don't think the major questions doctrine applies in the foreign affairs or national security context. So
is that the reason, talking to Professor Tim Meyer from Duke University School of Law, is that the reason you didn't mention him as one of the ones you were looking at most closely in this? You mentioned 3. You mentioned Coney Barrett, you mentioned Gorsuch, and you mentioned Chief Justice Roberts, but you didn't mention Kavanaugh.
Yeah, I think Justice Kavanaugh is a pretty solid vote for the administration here, for the government. He has signaled very directly that he thinks the major questions doctrine is not going to apply here. And Justice Kavanaugh, during his questions today, really put a lot of stress on these 1970s precedents. And you saw some of the other justices, including Justice Coney Barrett, say, I'm not so sure about these 1970s precedents. We don't decide cases the same way. You saw Chief Justice Roberts in the clip you played sort of push back on Dames and Moore v. Reagan, which is an early 1980s case. And the Supreme Court now is the bulk of the justices are, I think, much more textualist. They're much more sort of originalist in their outlook, and so it's not clear that they're going to put a lot of weight on those 1970s cases. But Justice Kavanaugh certainly signaled that he would.
But am I right that when this law was, I guess it's called amended, right? It was updated in the late 70s, that the purpose of it was to constrain presidential power?
That's right. Yeah. So this law is actually new in 1977, but it was
wasn't it based on something from 1917? Yeah.
Exactly. Yeah. It was based on a broader law called the Trading with the Enemy Act that dates from the First World War. And over time, what had happened was that there were these emergencies that the president had declared that just lasted for years and years. And so what Congress did is it stepped in, it passed a law that said, we're extinguishing all of the emergencies that existed at the time, and we're establishing a new framework to deal with these things. We're going to regulate very lightly, but regulate the process for declaring a national emergency. and we're going to separate the set of emergency powers that apply during wartime, which is still governed by the Trading with the Enemy Act, and those that are governed in peacetime, and that's this statute, the IEEPA.
So could Congress delegate to the president power to regulate commerce with foreign nations as he sees fit, to lay and collect duties as he sees fit?
We don't assert that here. That would be a much harder case now in 1790.
Isn't that the logic of your view, though?
I don't think so, because we're dealing with a statute that was a carefully crafted compromise. It does have all the limitations that I just talked about.
You're saying we shouldn't be concerned with. I want to explain to me how you draw the line, because you say we shouldn't be concerned because this is foreign affairs and the president has inherent authority, and so delegation off the books, more or less. And if that's true, what would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president?
We don't contend that he could do that. If it did,
why not?
Well, because we're dealing with a statute again that
backs off of this position as well after.
General, I'm not asking.
I have that clip ready.
Asking for your theory of the Constitution and why the major questions of non-delegation, what bite it would have in that case.
Yes, I would say by then you would move from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties, and tariffs and war. It's
2 seconds.
Authority all the way down, you say. Fine.
Justice Gorsuch, one of the people who Professor Tim Meyer from Duke University School of Law says he is eyeing. Pretty tough questions, but you were saying that he was tough on both sides.
Yeah, I think that's right. I think as you heard in that clip you just played, he was suspicious, I think, of the government's argument that it has constitutional power over tariffs that's sort of implicated by this statute. But when Neil Katyal got up to argue for the private plaintiffs, he was equally, I think, tough on Katyal, and there, the argument was IEEPA contains some language that says, the president can do, in this case, regulate by means of instructions, licenses, or otherwise. And Justice Gorsuch really sort of put some pressure on the idea that, if he can regulate by licenses, and he can regulate by license fees, that is a fee to, in exchange for a license, which the Supreme Court in a different statute that you heard the Solicitor General mention in a couple of the clips, Section 232, the Supreme Court said that you can collect license fees in those cases. That in those kinds of situations, if you can already do that, why isn't the tariff power part of what's delegated here without needing to get to, this Article 2 argument that the government was making?
You mentioned Section 232, and I want to ask you about that, because that's one that it seems the president has a lot more autonomy on, and you have to wonder why they didn't use that here rather than this Emergency Powers Act. And that one, and let me just read a little bit from that. That is from the Section 232 of the Trade Expansion Act of 1962. That would basically just lead to some evaluation of whether national security had been threatened, and the Secretary of Commerce would do that. There is some waiting period, right? The president has 270 days to determine whether he agrees, and 90 days after that to decide what remedy. But, you could do it very quickly. It could be done a lot faster. Why wouldn't they have just done it under that act?
So I think there's a couple of reasons. One you just mentioned is that there is a little bit of a waiting period. So no matter how, the administration already is using Section 232 quite a bit. Section 232 is what the administration used during the first Trump administration for steel and aluminum. We now have auto tariffs under Section 232. There's a whole variety of pharmaceuticals, semiconductors, investigations that are on the way that are likely to lead to tariffs. So the administration is using 232. But, the president likes to be able, what IEEPA allows the president to do is it allows him to wake up in the morning and say, I hereby declare a national emergency about, I don't like that the former president of Brazil is being prosecuted, Bolsonaro. And now there's a 40% additional tariff. And he doesn't have to ask for an investigation from an administrative agency. He doesn't have to do anything. I mean, he can literally wake up and announce new tariffs. So there's no delay at all. The other limitation in Section 232 is that it's product by product. So you have to do an investigation on semiconductors or on autos. And so what the president has tried to do with these IEEPA tariffs is he's just said all or basically all products from, either all countries or a subset of countries. So it's just a much broader authority with much less administrative work.
But the bottom line is that if the court strikes it down, he will be able to put these tariffs back into place, right?
That's right. Yeah. So tariffs are not going anywhere as a result of this. Case, and there are other, not just Section 232, but there's a bunch of other authorities that the president has that he can rely on. Some that he's used already, and some new ones that aren't really tested but are probably available.
Yep, I've got my whole list here of the different ways that he could do it, and I'll have to review those again once he makes a decision if he loses in this case. But Justice Barrett focused on the question of refunds, right? Because if the court rules that he didn't have the power to do this under IEEPA, then there are going to be refunds that are going to have to happen. And here is this number 9, Justice Barrett questioning Neil Katyal, who is representing some of the small businesses here against the administration. Let's listen.
If you win, tell me how the reimbursement process would work. Would it be a complete mess? I mean, you're saying before the government promised reimbursement, and now you're saying, well, that's rich. But how would this work? It seems to me like it could be a mess.
So the first thing I'd say is that just underscores just how major a question this is. The very fact that you were dealing with this with quotas, there's no refund process to the tunes of billions of dollars or embargoes, but there is here. But for our case, the way it would work is, in this case, the government stipulated for the 5 plaintiffs that they would get the refunds. So for us, that's how it would work. Your question, I take it, is about everyone else, where you don't have a class action or anything like that. With respect to everyone else, there's a whole specialized body of trade law, and it's in 19 U.S.C. 1514 outlines all these administrative procedures. It's a very complicated thing. There's got to be an administrative protest. There was a harbor management case earlier that this court was involved with in United States Shoe, in which the refund process took a long time. There were any number of claims and equitable relief.
So a mess.
So it's difficult, absolutely. We don't deny that it's difficult, but I think what this court has said in the McKesson case in 1990 is that serious economic dislocation isn't a reason to do something. Northern Pipeline, you guys stayed your decision for a while in order to let the congressional process unfold. There may be a congressional process here as well. You may be able to also be that this court could limit its decision to prospective relief under the John Q. Hammons case. So there's lots of possibilities.
Professor Meyer, I can't imagine that the court is going to determine this case based on the fact that it will be difficult to get refunds or give refunds, right?
I wouldn't think that would influence the court's decision. The fact that Justice Barrett was asking about that, I think is, the refund issue only really comes up if the plaintiffs win. And so I think, it's an indication in my mind that she's sort of thinking about, do we need to address not only the legality of the tariffs, but do we need to also say something about the relief in order to address this problem? But it's hard for me to imagine that the amount of the refund is gonna influence their decision. And it's a what we might think of as a moral hazard problem, right? So if the government imposes a big enough illegal tax, then they can get away with it. There's a pretty serious incentives problem if that's the law.
The number's 866-967-6887. Talking to Professor Tim Meyer about the big arguments today. I mean, the president is saying he thinks it's the most important case to happen. What do you make of my analysis, Professor, that I think some people are overstating the significance of this case? Because, look, what it seems to me is most significant about this case is that if the court rules against the administration, it will be the first time that they, in a big way, reined in this administration. I don't know that it's as you just said, they're going to be able to impose the tariffs again. It's not the president saying, "Oh, it's going to kill us economically." He can go do it again. It's almost as if it's symbolic that it's the first time that this court is saying, "No, you can't do it."
I think that's absolutely right. So I think in terms of presidential power, there's no president had ever claimed this power prior to January of 2025. So the presidency is not losing some power on which it has relied. It has never relied on this power. So the thing that is potentially more significant in a ruling for the plaintiffs is, as you say, I think that this will be the first, at least of this term, major loss for the government at the Supreme Court. I will say that a ruling for the government would be a dramatic expansion of the government's power. And this came up in the argument, which is that, there are a whole bunch of laws like Section 232 that have kind of administrative processes that are attached to them. And there will be no reason for any president to ever use any of those laws again if IEEPA can just be used to impose tariffs with a bare sort of what we might think of as a naked declaration of an emergency. That's unreviewable.
Yeah, that's a really good point. All right, so final question before we go to some calls here. Based on what you heard, what would be your prediction as to how this comes out?
I think it's going to be either 5-4 or 6-3 for the plaintiffs, for the challengers. That's my guess.
Yeah, and would you have said that before the arguments?
That was my guess before the argument as well. Yeah.
Okay.